Good day, I am Lady Mae Patac from BSHM 3A, and today's topic I am going to discuss Chapter 4 entitled Law on Partnership and Corporation. Learning Objectives. Differentiate the various kinds of partnerships and corporations and responsibilities of partners and incorporators. Identify the requirements in the formation and dissolution of partnerships and corporations. And here is the contents. Law on partnership, obligation of the partners, dissolution and winding up of partnership, order of liquidation for a general partnership, order of liquidation for a limited partnership, and law on corporation. So let's begin the discussion in law on partnership. The law, Article 1767. By the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund, with the intention of dividing the profits among themselves. Discussion of the law. Article 1767 defines the essential elements of a partnership, establishing the legal framework for this type of business agreement and governing the rights and obligations of partners within the partnership. Next, let's proceed to the obligations of the partners. First, where contribution is money or property. So partners who contribute money or property to the partnership and obligated to fulfill the agreed upon contributions. This includes ensuring that the contributed funds or assets are available for the partnership's use as agreed upon in partnership agreement. Second, where contribution is industry. Partners who contribute industry or work or services to the partnership are obligated to diligently perform their agreed upon rules and responsibilities. These may involve providing specialized skills, expertise, or labor necessary for the operation of the partnership. Third, obligation of the capitalist partner. The capitalist partner who primarily contributes capital to the partnership has an obligation to provide financial resources as agreed upon. Additionally, they may have responsibilities related to decision making, investment strategies, and financial management within the partnership. Fourth, responsibility between partnership and partner. So partners have fiduciary duties to act in the best interest of the partnership and fellow partners. They are responsible for upholding the terms of the partnership agreement, maintaining transparency, and avoiding conflicts of interest. Fifth, sharing of profit and loss among partners. So partners are entitled to a share of the partnership's profit according to their agreed upon profit sharing agreements. Likewise, they are also responsible for bearing a portion of any losses incurred by the partnership based on their respective capital contributions or profit sharing ratios. Sixth, property rights of a partner. Partners typically have property rights in partnership assets and may use these assets for partnership purposes. However, these rights are subject to the term of the partnership agreement and may be restricted or modified as agreed upon by the partners. Seventh, liability of individual partners to third persons. Individual partners are personally liable for the obligations and debts of the partnership. This means that their personal assets may be at risk to satisfy partnership debts, liabilities, or legal claims subject to any limitation or protection provided by law. And lastly, liability of the limited partner. In a limited partnership, the liability of limited partners is generally limited to the extent of their capital contributions. Limited partners are not usually personally liable for partnership debts beyond their initial investment, but they may lose their investment if the partnership fails. In summary, the obligations and responsibilities of partners in a partnership are crucial aspects of partnership law, governing the conduct, rights, and liabilities of partnership in their business endeavors. Proceeding to the next topic, which is the dissolution and winding up of partnership. The law. Article 1830. Dissolution is caused 1. Without violation of the agreement between the partners. 2. In contravention of the agreement between the partners where the circumstances do not permit a dissolution under any other provision of this article by the express will of any partner at any time. 3. By the event which make it unlawful for the business of the partnership to be carried on or for the members to carry it on in partnership. 4. When a specific thing a partner had promised to contribute to the partnership perishes before the delivery in any case by the loss of the thing. When the partner who contributed in having reserved the owner thereof has only transferred to the partnership the use or enjoyment of the same, but the partnership shall not be dissolved by the loss of the thing when it occurs after the partnership has acquired the owner thereof. 5. By the death of any partner. 6. By the insolvency of any partner. 7. By the civil interdiction of any partner. And lastly, by decree of court under the following article 1700A and 1701A. Article 1831. On application by or for a partner, the court shall decree a dissolution whenever a partner has been declared insane in any judicial proceeding or is shown to be as unsound mind. A partner becomes in any other way incapable of performing his part of the partnership contract. A partner has been guilty of such conduct as stands to affect prejudicially the carrying on the business. A partner willfully or persistently commits breach of the partner's agreement or otherwise so conducts himself in matters relating to the partnership business that is not reasonably practicable to carry on the business in partnership with him. 5. The business of the partnership can only be carried on at a loss, and lastly, other circumstances render dissolution equitable. Discussion of the law. Article 1830 and 1831 provide legal safeguards for partnerships, ensuring that dissolution can occur under specific circumstances to protect the interests of partners. While partnerships are typically governed by agreements between partners, these articles allow for dissolution even in cases where agreements are violated or circumstances change. These articles protect the right of partners by providing mechanism for dissolution in cases of incapacity, misconduct, or other detrimental situations. Articles 1830 and 1831 outline the various causes and mechanism of the dissolution of partnerships, ensuring legal clarity and fairness in the event of partnership termination. Proceeding to the next topic, which is the order of liquidation for a general partnership. The law, Article 1839. In settling accounts between the partners after dissolution, the following rules shall observe subject to any agreement to the contrary. The liabilities of the partnership shall rank in order of payment as follows. A. Those owing to creditors other than the partners. Those owing to partners other than for capital and profit. Those owing to partners in respect of capital, and lastly, those owing to partners in respect of profits. Discussion of the law. Take note that the liquidation process under above provision applies only to a general partnership. This is a different process for the liquidation of a limited partnership. So let's proceed to the next topic, which is the order of liquidation for a limited partnership. The law. Article 1863. In settling accounts after dissolution, the liabilities of the partnership shall be entitled to payment in the following order. Those to creditors in the order of priority and provided by law, except those to limited partners on account of their contributions and to general partners. 2. Those to limited partners in respect to their share of the profit and other compensation by way of income on their contributions. 3. Those to limited partners in respect to the capital of their contributions. 4. Those to general partners other than capital contribution. 5. Those to general partnership in respect to profits, and lastly, those to general partners in respect to capital. Discussion of the law. The above provision expressly provides for priority in the distribution of assets after dissolution of a limited partnership. Those due to creditors under number 1 Article 1863 are the outside creditors, including those owing to the limited partners. In the absence of any statement in the certificate as to the share in the profits to which each partner shall receive, a limited partner's share in the profits shall be in proportion to the amount of the partner's respective capital contribution. This proportional sharing takes place where the partnership assets are insufficient to pay each of the partners' claim. Proceeding to the last topic, which is the law on corporation. The law, Section 2, Corporation defined. A corporation is an artificial being created by operation of law, having the right of succession in the powers, attributes, and properties expressly authorized by law or incident existence. Discussion of the law. Right of succession means that a corporation has the capacity to exist regardless of the death, withdrawal, insolvency, or incapacity of the individual stockholders, and regardless of the transfer of interest or shares of stock. The power of all corporations are limited to those mentioned in their charters or in the General Act under which they are created. And that ends my discussion. This is Lady Mae Patac saying thank you and have a good day.